There was a consultation for someone who lied on their ESTA application, and somehow CBP knew that this person had lied on their ESTA. And when they entered the airport, they were put into secondary inspection and they were questioned by CBP. And although the client admitted to having lied on the ESTA form, um, CBP didn't admit them. His ESTA was canceled. And then since then, he's been trying to see if there's any possibility of obtaining a visa to come back to the US. And he hired an attorney who tried to submit a waiver of the fraud, but the particular embassy wouldn't even accept the waiver application. So they scheduled a consultation to get a second opinion with me about whether or not I thought that there was any other viable option. I think it's really difficult. Anytime someone commits fraud or a misrepresentation, that's considered a very serious offense, right? Because if you lie to the government, then why should they ever believe you in any future applications? Um, so my advice to the client was they could try again, but whether or not it would be successful, it's hard to say. They didn't really have a copy of the waiver application that the attorney had prepared. But from what I understand, the consular officer wouldn't even review it. So they just flat out said, we're not accepting any waiver applications. We're just denying your visitor visa application. Um, I don't know if it's something specific to that particular consular post. But just be aware that, there are pretty serious consequences to committing fraud or misrepresentation. And once that is on your record, it's really difficult to get that waived. Technically, there is a waiver of fraud. In this case, it's called a Harenka waiver. Harenka is the name of a case, probably the only case that I know of that talks about 212(d)(3)(a) waivers, which is a waiver to apply for a temporary visa. But, I think if the post is insistent that certain types of fraud or misrepresentation cannot be forgiven or rehabilitated, then, you know, you're kind of stuck with the consulate's decision. So that was one of the consultations this week. The other consultation I had this week was um, for someone who is now a green card holder, but they are a citizen of Afghanistan, and they initially were approved for an SIV, which is a special immigrant visa for citizens of Afghan who in some way worked with the US government or worked for a private company that had some kind of a contract with the US government. So I'm not really familiar with SIVs, never handled these types of cases before, but the gist of the consultation was that he received a letter from the US Embassy in Kabul basically saying that they have now decided to um, withdraw their um, approval of the SIV visa and that he only has 120 days to appeal this decision. But the interesting thing is that my client already has had his green card for 2 years. So I'm not really sure why the embassy is now saying that they found that there was something in his SIV application that is insufficient. It's not clear whether or not the embassy knows that he already is a permanent resident. And then the other question is, well, what is going to happen to his green card? Is he now going to have to worry about being placed into deportation proceedings and possibly face ICE trying to revoke his green card. So that's something that I need to do some further research on and hopefully be able to come back with some guidance for this client. But it seems like it's happening not only to him. I did find some resources online that said that this is a thing and that, to look out for what the government might do if they decide to um, revoke an SIV. So there's just so much going on with immigration now that it's like, what else is happening?